Good evening, everyone, and welcome to the Effective Living Centre. I'm Margaret Calder. I know many of you, and it's lovely to see faces from old times, from lecturing at different teachers' colleges, including Rick, of course, who taught when I was taught at the same college as I did when we were both teaching at the McGill Teachers College, or CAE, College of Advanced Education. Rick went on to greater things and has taught in many places all over the world. We have another thing in common because we've both taught at universities in Sweden. But it's really great to welcome him here tonight. He is an Emeritus Professor of Law at the University of South Australia, as you probably all know, but he's a past president of the Australian and the New Zealand Society of Criminology and a fellow of that society. So he's taught in the USA and in Sweden and at many other places in Australia and Hong Kong. He's worked too in Hong Kong and in Port Hedland, and you can possibly know why. He has a great interest in refugees, and he works with the Jesuit Refugee Association and Jesuit Refugee Services and the Australian Lawyers for Refugees. He's been on various boards, and they're all really, when you look at his background, he's been on boards that are associated with social justice and equity issues. So it's particularly good to have him tonight to speak to us. And people are just coming in, so I'll wait for them for a minute. There's a couple more out there. He's been a great friend of the ELC. He's spoken to us. 2012, he spoke on correctional services. He called it rehabilitation or revolving door. And that was a fascinating discussion that I still remember. He talked again on justice and punishment in 2017, when we also had somebody who worked with prisoners in a group called Second Chances. So Rick shared with her. And in 2019, he spoke again here at a forum on truth in our modern society, and he spoke again as part of a forum, and the other speaker was Dr. Colette Snowden from the University of South Australia, and we had Jules Schiller from ABC Radio, who was our MC for that night. And it was a really great night because we had discussion between the three of them and with the audience. And we'll do that tonight after Rick has spoken. He'll speak for 45 to 50 minutes. Being a university lecturer, that's about the lecturing time. And then we'll open it up for questions. So welcome, Rick, to our ELC once again.
Thank you, Margaret. I'd forgotten how many times I'd been here, but quite a delight for me to be back again. I've actually just come from a function at the Tandanya where we welcomed the new Attorney General, Khyam Ma, although Khyam told me he's been in isolation this week, so he couldn't actually go and be sworn in, even though he said he's already signed off on a bunch of things. So constitutionally, we have to wait and see whether they're actually valid. But he acknowledged, as we all do, that we're on Kaurna land and pay our respects to elders past, present and emerging. But it is fabulous, as you might recall if you saw the speech of Peter Malinauskas after the victory on March the 19th, that he said this is a government for all people and there will be a very strong Indigenous focus in the Labor Party for the foreseeable future. And I think I'm very pleased. I know I'm very pleased about that. Yes, I'm going to talk for about 45 minutes. And Margaret's given me a general topic about civil liberties. And what I'm going to do is pick 5 things which I'll call what keeps civil libertarians up at night. In other words, what do we worry about? Now, I'm not going to be going into too much detail about all the laws. We might cover about 30 areas of law tonight, so clearly I'm not about to give you chapter and verse in relation to all of those things. But in highlighting what is out there in terms of where law requires some modification, some reform, some appeal, etc., I'm going to be highlighting the ways in which civil libertarians tackle various societal issues. The 5 big topics are, and I'm going to take one at a time, freedom of speech. Obviously, that's probably the biggest one. So freedom of speech will be the first topic. Freedom of association. Who can we gather with? Can we gather tonight in this room? I can tell you we can, don't worry. The third one is the right of privacy. Where do we sit in relation to those laws? The fourth one is the whole idea of government transparency. I was listening to the news today about the trial of this young woman in China, and even the ambassador to China was shunted out of that particular forum today. So what do we say about governmental action on anti-terrorism, on state secrets, etc.? What's the level that we should be agitated about or agitating about in relation to government transparency? And finally, whether or not we have or should have an argument for a Charter of Rights. And I'll be talking about the Mark Parnell bill that failed 2 years ago and the fact that 3 jurisdictions in Australia actually do have such a charter. So, freedom of speech, something about freedom of association, something about the law on privacy and lack of privacy, something about government transparency and non-authoritarian pursuits, and finally something about the Charter of Rights. I'm also going to be mentioning something about my book, which you'll see is available tonight. It doesn't spend a lot of time on civil liberties, but I'm going to read you a couple of pieces from it in the hope that you might find some interest there. It's a memoir that I wrote last year, published by Moonglow Publishing, and Dr. Tanya Lyons at the back here tonight to sell you a copy if you'd like to have a look at one. And one other thing I'll do, just for the sake of the record, is that on a lot of these topics, I have committed myself to 800 words. There is a blog, some of you may have seen it, it's called The Conversation, highly regarded. It's only written by, well, you have to be a lecturer or an academic somewhere in order to write for The Conversation, and people reduce topics to 800 words. And I've had 55 contributions, about a third of those would be on civil libertarian matters, and the rest of them are just on legal matters generally. And I had a count last night, just to tell you, because the nice thing about these blogs is you can tell how many people actually access them because they're electronic. And up until last night, I'd had 1,840,462 reads. So I've probably written about 200 academic papers. I reckon I've had 1,000 people read those. But to have 1.8 million people read my 800-word versions, I'm rather pleased about that. So if you're at all interested in delving deeper into some of these things, particularly around association, Charter of Rights, privacy, drones, freedom of speech, various biometric things about our privacy, etc., you can always just search for me on the website, The Conversation, and you'll go straight to my blogs. So that's where we're going tonight. Let's start with freedom of speech. Some of you would know, having watched the movie The Castle, that the Constitution dictates some stuff and has a vibe in relation to other stuff. Well, I can tell you, unlike the American Constitution, or indeed the Canadian Constitution, which allows the Charter of Rights, there is no such thing as freedom of speech anywhere in any constitutional arrangement in Australia. It first emerged 30 years ago in 1992 when the Mason High Court decided that there was a vibe about freedom of speech in the Constitution which they called freedom of political communication. The logic went something like this. If we're going to have a vibrant democracy which involves people understanding the way in which politics works, we're going to need to be able to communicate that. And since the Constitution is premised upon having a vibrant democracy, therefore there must be freedom of political communication. Now you can see that's a little bit, circular, but the bottom line is for the last 30 years it's been pretty solid that Australians enjoy a constitutional right of freedom of speech, particularly in relation to political communication. That's the law. I say that's the law until last year. There was a very strange case, and again, you can read all about it. It was a case called Liberty Works, and the Federal Parliament had passed a law called the Scheme to Disclose Foreign Influence in Domestic Politics Act. The idea was it was limiting the way in which foreign institutions could lobby in Australia. It was pretty sort of anti-Chinese, in fact. And a crowd called Liberty Works, a kind of a libertarian group, challenged it, saying, well, that was kind of, shutting down things, because if you have to disclose who was lobbying, then obviously there's no freedom of political communication. And the High Court 5-2 said, no, the legislation's valid. But what was interesting in that is that Justice Simon Stewart, who is a new member of the High Court, said, quote, that the implied right of freedom of political communication is, quote, not settled law. So watch this space. It's becoming a fairly conservative court again. Remember, that 1992 interpretation was probably the most leftist-leaning High Court we've had in my lifetime. So is the implied right of freedom of political communication under some threat? Possibly. Watch this space. We don't know. All I do want to say in relation to freedom of speech is there are, and I've listed here, 7 different ways in which our freedoms to speak are constrained, and each of them is probably appropriate. I'll read them to you. The first, any sort of speech which incites violence is constrained. That makes sense. Secondly, seditious speech, we're here talking about really bringing down the government, is constrained. You can't report jury deliberations for a very good reason. You can't be in contempt of court, breaching suppression orders, for example. That's a constraint on your freedom of speech. There are a whole range of offences about Holocaust denial, race and religious vilification, and discriminatory speech, which is constrained. We'd think that's fair enough. There's all the stuff about defamation, which does constrain a lot of what we say. We can talk all night about defamation law, but generally speaking, it sort of strikes the right balance between freedom of speech and freedom against unfair and incorrect speech. And finally, anti-terrorism laws have dictated that we can't report certain things in relation to the way in which we're fighting terrorism. Now, I'll come to talk about that a bit later because I think they're actually overblown. But the bottom line is we do have a fairly constrained freedom of speech in Australia. It is not as broad as the United States, obviously, because they've then got their First Amendment, which says freedom of speech shall not be constrained. So we're kind of a bit further down that particular spectrum. Have we got the balance about right? It depends on where you are in relation to a particular matter on a particular day. I'm going to return a bit later to talk about anti-terrorism law, but that's kind of a quick overview of freedom of speech. What keeps civil libertarians up at night? Talking about how free that speech should be and what the appropriate constraints are. Number 2, where are we with freedom of association? Now, clearly we can meet tonight, no one's checking on us. Of course, in some countries, particularly authoritarian regimes like China and North Korea and maybe even Iran and some of those other places, meeting like this, particularly for religious purposes, is frowned upon unless you are registered. You can be a registered religion in China. Why do they register them? So they can control them. You're allowed to meet as a Christian in China, for example, but your religion must have been registered. We don't have those same constraints. Our freedom of association is pretty broad. However, there is a however here. It was always based upon a 1997 High Court case called Kruger, in which, for the first time, High Court judges started talking, but those of you who are lawyers might know the term obiter. By the way, not actually defining what the law was, but just saying and musing, by the way, there is a strong understanding of freedom of association in Australia. That's kind of one of those civil libertarian issues that we can kind of tick the box. Well, in the next dozen years or so, that started to be eroded. In the famous case of Mulholland in 2004, the High Court said, well, actually, it's not a freestanding right. It's linked to the freedom of political communication. So if we're meeting here tonight, and we're talking about politics, there's a sort of an absolute right to associate, because we're now talking about that so-called freedom of political association, communication, and that's an important part of the political democracy in which we live. But all of a sudden, there started to be some other challenges of that. And it came about when the state parliaments decided about 20 years ago they wanted to get rid of motorcycle gangs. Now, motorcycle gangs do some pretty nasty things, but the legislation was designed to basically break their back by saying you could not gather as a motorcycle gang. It was called, typically in most states, the Serious and Organised Crime Control legislation, although I must list what it was called in Queensland. You ready for this? The Vicious Lawless Association Disestablishment Act. And a lot of people thought that was deliberately written that way because it spells out Vlad. Well, we've got our own Vlad at the moment happening in Ukraine, but leaving him to one side, this was the Vicious Lawless Association Disestablishment Act. Here in South Australia we had the Soccer Act, the Serious and Organised Crime Control Act. And the idea was that it was going to say you cannot associate as a member of a motorcycle club or an outlaw motorcycle club. You're okay if you're riding, BMWs and Harley Davidsons and having child runs, the toy runs and those sorts of things. But anything that looks like it's going to be an outlaw motorcycle gang was going to be stomped on. Well, of course, they all then went to the various Supreme Courts and High Courts around the country, challenging this on the basis of our freedom of association, saying, wait a minute, you can't stop us from meeting as motorcycle enthusiasts. Oh, you're telling us we're dealing in drugs and standover tactics and prostitution. Of course we're not. We're just liking motorcycles. Well, not really, but the bottom line was they were challenging the law on the basis of it throwing a spanner in the whole idea of us having freedom of association. And case after case after case, once the legislation was tweaked, came back and said governments could do that because the overriding purpose was to cut down on crime. And if there's some suggestion that what you're doing in associating is criminal, then unfortunately the crime control legislation outweighs your freedom to associate. It's called the Principle of Legality, that if the parliamentary legislation is clear enough, you can't imply this, if it's clear enough and shuts down motorcycle gangs, then the freedom of association goes out the window. So what we can say about freedom of association is it's there, but if what you are doing has another purpose which worries people, particularly a purpose which has to do with criminal intent, there is no such thing as freedom of association. Let's get to, no freestanding right that you can wave a flag in Australia, freedom of association. If the principle of legality comes along and Parliament says what you are doing is now inappropriate, that will prevail. In other words, if the Parliament tomorrow said you cannot meet in the Effective Living Centre and they pass legislation saying that, there is no way you can go to the High Court to challenge that. I'm sounding a bit scary here, but there's no freestanding right of association. Okay, the right of privacy. I begin this particular part of this talk by talking about the way in which back in 1979, I at the time was studying in the United States, and I had a bit of a European holiday during the Christmas break with two other friends of mine. It's actually the story's in the book. And we went to East Berlin. Went through Checkpoint Charlie. Who did that before the wall came down in 89? A few of you would have done that. You got on a train, you went under the river, and you emerged in East Berlin, and there you changed some money. There was an obligatory purchase of 5 East German Deutschmarks, and then you wandered around. Well, we wandered around. We went from Checkpoint Charlie, we wandered to the Brandenburg Gate. The Brandenburg Gate was totally inside East Berlin, completely deserted. Of course, you go there these days, there's a million tourists milling around looking at where the wall used to be, a couple of 100 metres away from it. And there we were, wandering around. And as we wandered around, a whole bunch of people were looking at us. Typically, they were looking at us in around the corner. There were sort of pillboxes with these little slits. And everything we did was being observed as we walked from Checkpoint Charlie to the Brandenburg Gate and back again. And I commented to my American friends, I said, this is where freedom is in the West. In the West, we can walk around unobserved. There are 800 million CCTVs now around the world, most of them in Western democracies. The bottom line is we are now far, far, far more observed than we used to be. And that's happened by accretion, and indeed, for the most part, by people saying, well, to the extent that that allows us to be safe from being knocked over the head and to solve crime where it has occurred, and how many of those crime shows do we see where they keep going to say, let's see what the CCTV told us about this, this and this, and they track the perpetrator, etc. You can see where this has emerged, but it's emerged quite dramatically in that last 30 years or 40 years. And so I take you in my writings, my various writings in relation to privacy, through the advent here 50 years ago in South Australia through the Listening Devices Act, which later became the Listening and Surveillance Devices Act, which is now found in every state. The idea of that being that a person should not be able to pry on someone else. However, there is a lot of howevers here, and our privacy is not that secure to the extent that a person can place a listening and surveillance device if it's ultimately in the public interest. My quick little anecdote on that is that back in 2010, some of you may know, I stood against Christopher Pyne in the seat of Sturt, and I was somewhat disappointed with the fact that Julia Gillard had become the Prime Minister and was talking about climate change. But as far as I was concerned, she wasn't taking it seriously enough. This is now 12 years ago. And people knew that I actually had a view on climate change which was somewhat aloof from the then Prime Minister, who had just taken over from Kevin Rudd just ahead of the 2010 poll. And I was at a street corner meeting, as you do, and this woman came up to me very close, and I thought a bit strange, and she was sort of clutching her handbag, and I thought that very strange. She said, "What do you think about Julia Gillard on climate change?" And I said something along the lines, well, yes, I'm disappointed that she hasn't made a stronger statement about the various things the Greens were putting up. Nevertheless, it's far better than the opposition, I can tell you. I wouldn't go down that particular path. So to that extent, as your representative, I'll be fighting for a stronger view on this. But I use the word disappointed. Anyway, I went back home thinking that street corner meeting was very good. And I got a phone call from someone at News Corporation saying they'd like to play me a tape. And the tape was the tape of my voice on a recording device in this woman's bag. And no wonder she was close to me, because she wanted me to say that. My feet went cold. I was more fearful, of course, about the Labor Party than I was about anyone else, that they were going to excoriate me for breaking ranks, because the story then becomes Labor at odds on policy. And that's where the story then becomes a story, not about the policy itself, but about the fact that I'm now speaking against where the policy is, and there's division in the ranks. That becomes the story. So I said, now wait a minute, you can't print that, got on my high horse, because of the Listening and Surveillance Devices Act. You don't have my permission. They said, Rick, you would know, Section 4 talks about the public interest, and this is public interest. I knew they were right. And luckily for me, it didn't appear in the Australian until about page 6. So it wasn't front page news. But the bottom line was it was in the public interest to know, and of course any court would hold that notwithstanding they had taken an illegal tape of mine of saying something in a public place which I had intended to be private between the half a dozen people who were there, notwithstanding that, the public interest demanded that be available. And again, that whole idea of privacy, of what you were doing, what you're saying, where you're saying it, who you're speaking with, is again one of those very delicate balances about making sure that we'd like to have our privacy, but if the purpose of that privacy is to hide some sort of nefarious activity or to break a confidence or to bring down the government for whatever reason, then your privacy is always going to be suspect. So that whole idea of privacy, where civil libertarians stand on that, is a very great dilemma. Civil libertarians love the idea of privacy, but they can also recognise in some instances there are certain things we don't want to be private if our governmentality and our transparency of government, for example, is at stake. So in my writings, in the conversation, I talk about all the new biometric identifications, the body scan, the facial recognition. And you might remember there was 7-Eleven were putting something out just last year saying that a person now coming into the store will have their face through facial recognition. The whole idea being that a person who's now going to be deemed to be a criminal person or an undesirable won't be let into the store because their facial recognition would be a tip-off for that particular organisation. Can they do that? Yes, they can, because there's no law against using facial recognition to keep you, your customers and your staff safe. But there's a worrying trend, generally speaking, that there we were back in 1979 in front of the Brandenburg Gate, touting the fact that one of the great things about Western democracy was that we weren't being pried upon all the time. There's a worrying trend that keeps civil libertarians awake at night concerning how far it is that we will go to have people being observed through their gait, through their iris, through their facial recognition, through their voice patterns and those sorts of things. It's something that, of course, we'll have to talk about if you'd like to pursue a question on that as we go along. Okay, number 4, transparency in government. This whole idea is that we don't want to live in a government which is authoritarian. We recognise how difficult it would be for a person living in Russia to say something against the government about the way in which they're invading Ukraine, or in China, or in North Korea, or in a lot of other countries around the world where your comments about the transparency of government are under some sort of scrutiny, and you can suddenly have a visit at night saying, "Come with me," Stasi-like, and be dragged off and questioned about your position on certain things. This came up, of course, particularly in relation to masks and vaccination, which we could pursue if we want to during the question time. And the civil libertarian view on this was a very difficult one, because on the one hand, the last thing civil libertarians want are governments telling you what to do when you don't particularly want to do it. In fact, the Labor Party was caught up in this as well, insofar as the government was mandating certain things and Labor fell in behind them. For a very good reason. The idea was, as Labor's always said, if the Marshall government was saying, with the best information available from the science, that we needed to have masks, we needed to be vaccinated, then they were prepared to make those stipulations. And the Labor government got right behind that, saying the last thing we need in this whole debate, very delicate policy debate, is to have confusion and obfuscation and basically mischief-making by oppositions. That was the last thing we need. So we want to have a sort of a bipartisan approach to this. Well, during this last campaign, the 2022 election, I was running in Bragg against Vicky Chapman. Went down, as was always going to be the case, since Vicky holds a very large margin in Bragg. I had a number of people call me on the telephone on my position on mandated vaccinations and mandated masks. And so there's a lot of concern there about saying this is not a civil libertarian position, but the civil libertarian position was always take the science and do what's appropriate. So we fell into line with that, notwithstanding other civil libertarians would have said, I'm sorry, but that's just asking too much of me as a citizen to fall in lockstep with a government just because they think it's right for us. Leaving that to one side, we can talk about that a bit later. Other things are like the transparency that we had back in the 1970s of the introduction of freedom of information laws, which for the most part most people recognise are fairly toothless insofar as a government can just redact stuff from those very quickly on some very broad parameters within the legislation. One of the more concerning ways is the way in which we have some in-camera hearings. Camera is the Latin word for closed. That's why you have a camera, because it's closed. No light gets in while you're taking a picture. So an in-camera hearing is a closed court. And we've now got the, I think, dreadful position where Bernard Collaery, who's been charged in relation to his standing for a client who was prepared to blow the whistle on the way in which the Australian government bugged the East Timorese during the oil sea negotiations, or the offshore rights in the Timor Sea, in the Timor Gap, is now being held or charged with a whole bunch of matters to do with breach of state secrets. And those hearings are being held in camera. And a civil libertarian would say, I'm sorry, but that's just not open, transparent government. I'm going to read you a little bit more from Michaelia Cash, who answered us on that a bit later. But that keeps civil libertarians up at night in relation to in-camera hearings. If you're going to have someone being charged with offences and those offences need to be examined by public scrutiny, you can't have a situation unless, of course, there are highly delicate state secrets. You can't have those hearings away from the public eye. We do have, since 2018, a piece of legislation called the Independent National Security Legislation Monitoring Act. This was brought about as a way of ensuring that legislation wasn't cavalier in taking away people's rights for that transparency. But of course, from time to time, there's been anti-terrorism legislation at both state and federal level, which have had the effect of limiting the way in which we can comment on anti-terrorism activities in ways which civil libertarians think are very, very limiting and over the top. For example, it still is the case since 2014 that you cannot, as a person, and certainly not a journalist, disclose a special intelligence operation. Disclose one, that there was a special intelligence operation. You get 5 years if you do that. That just seems very strange to me. If you name an ASIO agent, it's a 10-year prison sentence for doing that. And I tend to think that we need to have some more balance there. A civil libertarian would say, I'm sorry, but you've got to have a fair and free and challenging, courageous press. If you've got a special intelligence operation which is all screwed up, for example, you're going after the East Timorese politicians discussing what they're thinking about the particular treaty-making process, the last thing you want is to have governments hide behind their bumbling on the basis of saying, I'm sorry, that was a special intelligence operation, you have to shut up. So there is another review of the Independent National Security Legislation Monitoring Act, and I'm pleased that it's there. The whole idea of it, of course, being to make sure that when we do have legislation, it passes muster in terms of having the transparency and the non-authoritarian government stuff that otherwise would cause civil libertarians great concern. There was a case, the Lodi case, Lodhi case back in 2006, where there was a challenge to a whole bunch of anti-terrorism legislation. And again, it came down to this principle of legality, that if the Parliament says that we have to constrain these rights on the basis of this, this and this, and they make it clear enough, it's not unconstitutional. In other words, there's no overriding freedom of information from government that can't be constrained by direct legislative control. As a civil libertarian, I think that's okay, so long as you've got your faith in your Parliament. And I must say, I do like the way in which we have a constitutionally appropriate Parliament. I can tell you, having lived in the United States for a long time, having the idea of a president who can walk away from a press conference or send out his, I was going to say or her, that's not going to happen for a while, his or her aide to go and answer questions while he doesn't have to answer them. My goodness me, aren't we glad we have a question time in our parliaments where no minister can hide behind a direct question. Mind you, they're brilliant in the art of obfuscation and going around not answering the question, but that fulcrum in the Parliament is a far, far better way of doing democracy than having a president who can make executive orders than walk away from a press conference. But the bottom line is, if you have direct legislative mandate, then there is nothing that a person can do to claim that a constraint on transparency or a constraint on freedom of speech in relation to those matters. There's nothing you can do to claim that's unconstitutional. Okay, let's talk about a Human Rights Act. This will be the last of my five. This is whether or not we should have some sort of human rights legislation in our quiver. There are 3 jurisdictions in Australia that have passed human rights legislation. The first was the ACT, the second was Victoria, and the third most recently was Queensland. Essentially what they do is they set up what the human rights are and proclaim them and if a person believes their human rights have been in some way constrained, they can go to an organisation. If it was here in South Australia, it would be our Civil and Administrative Tribunal to test the waters on that. Back in 2020, Mark Parnell of the Greens tried to put up a similar piece of legislation here in South Australia, and it did not pass. At a forum last year, I challenged Khayyam Ma, the now Attorney General, then the Shadow Attorney General, as to whether or not it was Labor Party policy to put up a Human Rights Act similar to the Parnell Act, which I'll explain a bit later. And he said, in fact, I took it to the Labor Party Congress about a year ago, and it was watered down to the Labor Party will undertake further consideration of a Human Rights Act here in South Australia. So they're not committing themselves, but they may. They've got 4 years to think about it, and generally speaking, it was more likely to occur from a Labor Party than it was from the Conservatives. The Mark Parnell Greens objects of the legislation, which is very similar to the Victorian legislation, was fivefold. One, to kind of set out to explain what human rights are. Number two, to make sure that if you're interpreting a statute that's come before the Parliament, you interpret it with the idea of human rights behind you. I'll give you some examples of this a bit later. I'll just tell you what the Act was doing. Number three, an obligation on public authorities who have decisions to make to premise those decisions on considering their human rights outcomes. Number four, very similar to the others, that all bills coming before the Parliament would have a health check on their human rights. And number five, that it should be within the jurisdiction of the Supreme Court, and that would be added to the Supreme Court jurisdiction, to declare that a particular statute should not be interpreted against human rights. So that's the objects of a Human Rights Act, to kind of embed the idea that we start everything with human rights. Let me give you 4 examples which came out of something I just read the other day when Queensland was explaining to its members what it had achieved in the short time that they'd had a Human Rights Act. And I should say that the feds have always walked away from a kind of a Charter of Rights. A decade ago, Frank Brennan had a commission of inquiry that looked at a Human Rights Act for Australia, which, whether you embedded it into the Constitution, which I think he decided was never going to happen. We just don't like changing the Constitution. But a Human Rights Charter, his group said, would be a good idea for Australia, but it hasn't been picked up by the Labor Party. It certainly has not been picked up by the Conservatives, and is unlikely to become an issue in an election in the years to come. But leaving to one side the federal idea, it's more likely to happen at the state level. And will South Australia go down that path? We'll have to wait and see what Khayyam Ma does in his first 4 years. So here's 4 examples that emerged from Queensland, where they were talking about how this had had some effect upon the way in which day-to-day operations of people were changed by virtue of having the legislation. Not much point having the legislation unless something changes. They give these 4 examples. A man had been released on parole, and one of his parole terms was that he had to find stable housing. But the housing, he was given he could only be released on parole if he could show stable housing. But he went to the housing authority, and they decided that because he was a prisoner, he was not a priority. Now, he's caught in a catch-22 there. Either he gets parole and finds some stable housing, or you can work it out. But the bottom line was he's caught in a catch-22 and a human rights position on whether or not he got parole or got housing. One of those 2 things had to change. And so that authority would have to have changed his or her mind over giving that person parole without stable housing or finding some housing for him, because that was a condition of parole. I think it was the latter of those 2. Number 2, we don't have direct laws which abolish modern slavery because it's so difficult to determine. Obviously, if a person's being held against their will and they're in slave-like conditions, that's a criminal offence. But a person who might be a person who has been flown in from an overseas country, now working at a job, but her work requires her to engage in sexual servitude, and we all know that basically call services and prostitution services are given a blind eye. and has to hand up her passport, or most of the wages go on accommodation, it's not a direct criminal offence, but by crikey, that person's human rights are being offended, and that person, if we had a Human Rights Act, would have a remedy to ensure that that particular situation did not persist. Number 3, oh yes, this was another illustration where a young woman who was about 14 was excluded from school because of her behavioural issues. We understand that's going to happen in some schools, but there wasn't any provision for her in that particular place where she was living to have the sort of proper psychological care to help her through those behavioural issues. So again, caught in a catch-22. She's going to persist with the behavioural issues and get excluded from school, but while she's excluded from school, she's not getting any assistance to get her back into that particular school. A Human Rights Act would recognise that something has to break there. Either the school has to work with those behavioural issues in some other way, or if she has to be excluded from school for those behavioural issues, that she's given us a support network to enable her to re-enter and be restored in that school environment. And the final example the Queensland government gave, oh yes, an Aboriginal man was in custody, and because of his behavioural attitudes in prison, he was in solitary confinement. But he had serious mental health issues. But in that prison environment, there were no mental health services. So simply putting him in solitary in order to deal with his behavioural issues, because he couldn't be in the yard, was not going to be assisting the mental issues that he had. Either he was given the provision of services, or he was relocated to somewhere else where those services could be provided within the environment. So those are the sorts of things which typically you can see there's no direct legislation that applies to any of them, but every one of those relates to someone who's sort of caught in a catch-22 position. So my own view on that is that I think South Australia, and a civil libertarian would say, one of the best ways of ensuring the civil liberties of a particular citizen is to ensure an underpinning of human rights in such legislation. So I would certainly say that a civil libertarian would be the first person to go after that particular piece of legislation. Just to give you some idea about what we do in the South Australian Council for Civil Liberties, I spend most of my time writing letters. I write letters to Stephen Wade, or not anymore, in relation to matters concerning the COVID Safe app, for example, which I thought was a bit of a waste of time, which of course it was. But generally speaking, we have our meetings, we think about things that need to be pursued, and then I write to the various person. And on this occasion, I wrote to the Senator, the Honourable Michaelia Cash, who took over as Attorney General after Christian Porter's demise. Look, I'm not going to read the 3 pages here because obviously we'd be here most of the evening, and she's obviously got a good law student in her opera. Oh, look, did she write this herself? Of course she didn't, but it's beautifully written and beautifully obfuscating, I should add as well, and sidestepping. So thank you for your letter, Rick, of 11th of June 2021, raising various matters on behalf of the South Australian Council for Civil Liberties. Each of these matters is considered further below. Now, obviously I won't go into it, but I'll just introduce you to the topics and see where the government, the federal government in this instance, was defending a position which we believed in every case was somewhat untenable. You might remember the prosecution of a whistleblower called Richard Boyle, whose matter has now been finalised when he pleaded guilty and was given a very, in fact, I'm not sure he even got a conviction. The whole thing was ridiculous to go after this particular prosecution of this particular whistleblower, and she was saying, I don't consider it appropriate for me to issue a direction in relation to this matter. That's the answer to most of them. But we were concerned about them going after a whistleblower who was talking about bad government policy. Then there's the prosecution of Bernard Collaery and Witness K, which I still think is the most outrageous thing. Those of you who are at Writers' Week this year would have heard from Bernard Collaery talking about the way in which they continue to persecute him. And the federal government should just step away from that and say, look, it was a bad instance, but they've got so far into it now, they can't do that. And notwithstanding, all he was doing was highlighting the government's outrageous bugging of the East Timorese negotiations concerning the oil that was available in the Timor Sea. It just seems bizarre to me that they're considering in relation to that particular matter. the handling of national security information is a decision for a court which can make orders it considers appropriate about such matters, including whether to hold parts of the proceedings in camera. In other words, full steam ahead. There's a piece of legislation, I should add, called the Public Interest Disclosure Act. Back in 2013, the Public Interest Disclosure Act was designed for government transparency, so full marks to what would have been the Abbott government back in 2013. There was a review in relation to that piece of legislation by Philip Moss, called the Moss Review, with 33 recommendations to improve the operation of this particular act. It was our view, and the view of civil libertarians around the country, that although we have the Public Interest Disclosure Act, it simply wasn't being carried out in the way it should have been carried out to have public interest. And of course what Michaelia Cash is saying, that isn't it wonderful, we've got this piece of legislation and we're looking at those reforms and we're looking at the strengthening of the ability of agencies to recommend that disclosures be investigated, blah, blah, blah. So again, just a bit of an obfuscation in relation to what we were asking for, some hard evidence that the government was serious about public interest disclosures. There's a whole paragraph or 5 here on the age of criminal responsibility, which civil libertarians are very concerned about insofar as we think that the age of criminal responsibility, which currently is 10, is completely out of kilter with the rest of the world. And those of you who know from the various discussions we've had in the last half a dozen years that this has the effect of putting a lot of Aboriginal kids behind bars. I think, from memory, I haven't looked at it for a while, but there's something like 600 kids around Australia tonight who will be in custody, and 50% of those are Indigenous. So that's an outrageous 50% when, of course, they're only 2 or 3% of the Australian population. And the bottom line is a lot of those kids are 10, 11, 12 and 13. And we're of the view that we should bring ourselves in line, certainly with Western Europe and Scandinavia, and making it 14. Would you believe it's 14 in China? So in fact, we could actually follow the Chinese in relation to that. So she's talking about the fact that the meeting of Attorneys General agreed the minimum age of criminal responsibility would be further considered, noting the overwhelming majority of offences are in state and territory offences. It's not a matter for me. The government engages with jurisdictions to ensure treatment of young people in detention meets all expectations for the safety and protection of children under government care. In other words, no, we're not going to do anything about that. 2 more quick ones before I finish. There is a new bill before the Federal Parliament called the Data Availability and Transparency Bill. Again, this is a laudable piece of legislation designed to ensure that if you have data sharing between government departments, particularly with MyGov, now linked if you want it to be, to your tax records, to Centrelink, to you're going overseas and travelling around the world, then that data those data are vulnerable to governments prying on them and using them for inappropriate purposes. So we have a thing called the Office of the National Data Commissioner. He has commissioned 3 independent privacy impact statements in relation to the Data Availability and Transparency Scheme. We are of the view that people who were not empowered with their own financial and employment and mental acuity would be particularly vulnerable because they'd been left behind under this legislation. So what we were saying was we needed to have some greater assurance that the Data Availability and Transparency Bill was going to make sure that powerless people were going to be embraced by it in a way that would empower them. And Michaelia writes, the bill is now being considered by the Senate Scrutiny of Bills Committee, the Senate Finance and Public Administration Committee and the Parliamentary Joint Committee on Human Rights. The government is carefully considering the recommendations by these committees to assess whether any amendments to the bill are required. So, look, I don't want to say the governments are not concerned about transparency, but again, they're always trying to ensure the balance between privacy and transparency and government security of secure information in a way that civil libertarians are kept up at night, making sure that nothing is decided that has overburdened citizens with governments making high-minded decisions which are inappropriate. So again, there's good legislation out there. Civil libertarians are concerned to make sure that when it says it's going to do something, it does it, and doesn't do obfuscation or pushing things away, or in some way jettisoning the way in which that operation should occur. And finally on this letter is the Commonwealth Magnitsky Act, on which the government has stalled somewhat. Some of you may not have heard about the Magnitsky Act. Magnitsky was a Russian who was basically killed by the Russian government because of his opposition to the Vladimir Putin regime. And legislation has been passed throughout the United States and right across Europe, which has the effect of freezing any assets of a government and oligarchs, particularly Russian oligarchs, who engage in those sort of international conspiracies to kill citizens who are trying to blow the whistle on those governments. Now, of course, that's exactly what's happening now in relation to the freezing of assets of the oligarchs who are supporting Vladimir Putin. The Magnitsky Act, if one were passed here, would have the effect of making the government, or obliging the government, to freeze any Russian assets of any person identified as having had some part to play in a nefarious episode. And on that, the government seems to be moving fairly quickly. I'll read this to you. The Minister for Foreign Affairs, Maurice Payne, referred at terms of an inquiry into the use of targeted sanctions to address human rights abuses. After a year-long inquiry, on December 2020, the committee tabled its report recommending Australia establish a Magnitsky-style human rights sanctions regime. The government is carefully considering the 33 recommendations and will respond in due course. The government has not responded yet, but I imagine, although I haven't seen it on Albo's lips at the moment, that a Magnitsky Act in Australia wouldn't be too far away, particularly given the events in Russia and the Ukraine at the moment. Now, that's my 45 minutes, but I do want to take the liberty, with your permission, and hearing no objection, to read from my book. Now, I should say this book of mine is an insight into what's called Life Actually. It's 154 stories, all of 500 words, where I try and capture the essence of what it is that's made me the person I am. And typically, it talks about good people and values like trust, love, respect, confidentiality, etc. It doesn't directly affect civil liberties, but Margaret did give me the permission to read a couple of things from it tonight. So just to give you a taste, let me, with your permission, read you a couple of stories. I was looking last night to see which ones actually could be tied to issues of civil liberties. That must have to be the next book, I think. But this one's called Personal Privacy. We all love our privacy. While it might be nice to be famous, most of the stars typically remark when asked that the thing they miss most is the opportunity just to walk down the street unnoticed. I often wonder too what it must be like to be a member of the royal family when you need a quiet pee, or to have a terrible urge to fart loudly. Where do you go? It's all very perplexing. An expression used rarely these days is to perform one's ablutions. My erstwhile pastor, Peter Taylor, in his announcements at the beginning of youth camps, would invariably give a direction that we needed each morning to perform our ablutions before coming to breakfast. I had no idea what he was talking about, but assumed he meant having a pee and washing our hands before we paced the world. One does need some privacy when performing ablutions. Thus, it was somewhat unnerving when I arrived at Graceland College student residence, this is back in the late 70s in the United States, to find very little privacy was observed in the men's bathrooms. On my first morning on Aaron House floor, I closed the toilet cubicle door and settled on the seat. I then noticed two heads that appeared over the partitions, each side of me. Yes, I queried. We don't close doors here, my new residential colleague advised, unless you have something to hide. I figured that was a reasonable observation and duly opened the door. I left the door open the following day on every occasion after that during my time at college. In fact, after I left college, I felt somewhat claustrophobic if I shut any cubicle door behind me. It was a strange feeling. It's gone now. Any mention of toilets requires my recounting an experience I had in China. Anyone who's been to rural China knows it's an unsettling place when it comes to human waste. This was brought home to me when we visited the rural city of Shufu, hometown of the famed educator Confucius. There, if nature calls, one adds to the pile of excrement on a stone slab ahead of its being transported to the fields at the end of the day. It's a little disconcerting, especially if there's been a line-up at the doorway ahead of you. Equally disconcerting was the toilet block in another town where friend Stephanie and I parted ways at the top of the garden to follow separate paths to the toilets, only to find out we ended up under the same roof with the same drain, separated by a flimsy steel partition about 1 metre high. "You go first," she said. One cannot leave the issue of privacy without referring to the growing worldwide ubiquity of privacy-challenging tools. There are more than 800 million CCTV cameras installed in the world today. I should say 90% of those are privately owned. This is not government CCTV, these are private ones. Voice and facial recognition, drone and metadata surveillance technologies are leading us into a brave new world from which there will be no retreat. It's more than a little disconcerting. Those two heads observing me in the toilet cubicle now pale into insignificance. And at the risk of reading too many stories, I'll read one more. The reason I'm going to read this next one is because it's actually Tanya's favourite story, and it's called Russian Encounters. And given we're talking about Russia and the Ukraine, it's probably appropriate to read this one. I'm no great fan of cigarettes. The World Health Organization tells us that around the world, tobacco kills more than 8 million people each year. I've seen too many of my friends and acquaintances succumb to the ravages of the evil weed. Hence my dalliances with the cancer stick have been brief, so brief in fact that I can remember all 4 of them. The first 2 occurred on scout trips. Baden Powell would not have approved. And the third was the Adelaide Zoo on a Year 9 science excursion, because one teacher cannot see all 24 boys at once. The fourth was in the Soviet Union. I was there on a study tour from my Canadian university. This was back in 1985. The fourth was in the Soviet Union, and there are extenuating circumstances. I arrived in Moscow in my Levi jeans, Donner mountain boots and goose-down jacket. That made me an immediate target for touts looking to engage in what they referred to as red market transactions. Want to buy some money, or change some money? Want to sell me your jeans? Want to buy some strange things? Strange things was a direct Russian to English translation of religious icons. Want to sell me your boots? I remember this last one especially because I answered, but I'd have nothing to wear on my feet, to which the Soviet hawker replied by simply pointing to the decrepit pair of shoes on his feet that he was apparently willing to offer in return. I bought 2 packets of Camel unfiltered cigarettes from the Berezovka shop. Anyone been to the Soviet Union, the Berezovka shops? The Berezovka shops basically take hard Western currency, so they want us to shop there, not out there in ruble land. I bought 2 packets of Camel unfiltered cigarettes after I learned that was the price to get my coat repaired by the hotel seamstress. To escape the touts in the Russian streets, I decided to go undercover. I went to the market and bought a pair of really daggy trousers, an old faded military jacket and a Russian sailor's peak cap. I looked very Soviet, but to go further and create the illusion that I could have been Chekhov or Solzhenitsyn, I bought a packet of Russian cigarettes. I lit one and deployed it hanging off my lip in a very jaunty fashion. I sat in Gorky Park one afternoon armed with a telephoto lens on my Pentax SLR, capturing on Kodachrome the people who passed by. I imagined that I was a spy. It was a surreal experience. I brought that packet of Russian cigarettes home with me and gave them as a gift to my friend and colleague at college, John Shelley, as he was a smoker. The following day, John announced over morning tea, "Rick tried to kill me yesterday." All eyes turned to me, then to him, for evidence to back up this grievous allegation. He gave me these Russian cigarettes. I had one last night and almost died. 3 decades later, I'm pleased to report that John is hale and hearty. He no longer smokes. I don't think there's a direct connection between my gift and his abstinence, but I'm confident that I can proclaim I saved John Shelley's life. Now, we could actually have question time now, which I think we're going to have. You could ask me to read more stories, or we could talk about civil libertarian issues. So I'll take any questions. Fergus.
No, not me. I'm bringing the mic to you if you want to ask a question. Just put your hand up, please.
This is a bit like being in an auction, waiting for the first bid. Margaret, I see Margaret's hand, Fergus.
Margaret definitely has a question, I reckon.
I've
got a question because it's one when we were talking about your talk, and I asked about refugees, and you said there's now I lost the word. Interconnection between civil liberties and our treatment of refugees in Australia. I wonder if you will comment on that.
Yes, Australia is a signatory to the Refugee Convention, which means that if a person arrives on our shores seeking asylum, and we are the first port of call of any country that signed on to the Refugee Convention, we are obliged to determine that refugee claim. However, you'll know that successive governments, at Labor and Liberal, the Conservatives, have positioned themselves, certainly in the last 20 years, in ways that has made that very difficult to do. Now, when I was working in Port Hedland with Australian Lawyers for Refugees, that was in 1993, so that's, gee whiz, almost 30 years ago, when in fact we were taking these obligations seriously. Then the boats started to arrive, our politicians got spooked. Unfortunately, a lot of those boats started to turn over and people drowned, and suddenly the population got spooked as well. And as you know, things sort of fell in a bit of a hole since that particular time. Now, in terms of civil libertarian issues, a civil libertarian typically would say that a person who arrives on our shores by whatever means has the right to apply for refugee status and be given refugee status in the country. To the extent that we've now had, through the process of legality, as I said before, direct legislation that's talked about the so-called Pacific Solution, the no person can ever continue to live in Australia having applied for refugee status here, etc., then the legislation prevails. And so the civil libertarian issue says, but wait a minute, what about that international agreement that we have struck with the treaty that we have struck in relation to getting into line with refugees? And the bottom line is Australia has an appalling record in upholding upholding our obligations under those treaties, because after all, our parliaments have sovereign rights. So typically speaking, a civil libertarian would say, surely there is something that overpowers legislation, sovereign legislation, by virtue of an international treaty. And unfortunately, our constitution allows our sovereign parliaments to make decisions that fly in the face of our treaty obligations. And there is no way that international law can demand that we act otherwise. So the connection is that a civil libertarian will continue to tout our being a signatory to international covenants, conventions and treaties which uphold human rights, while decrying governments who legitimately trample on those rights. You might recall, as we wait for the next question, you might recall there was also a human rights watch who came out and looked at the way in which our young people were being detained, particularly with spit hoods and those sorts of things in the Dondale Detention Centre, for example. And the government said, well, that's all well and good, but we're not doing too bad a job, and some of these kids are outrageous. In other words, it doesn't matter what a human rights group might say, the governments have always got an answer. And we don't always have a strong parliamentary opposition to that, because unfortunately, if you put up a strong opposition to that, the government of either persuasion will call you soft on crime or soft on whatever. In other words, you're just pandering to these outrageous children. And unfortunately, that sticks in the public mind and the public eye. I've often said we would have a lot better policy if we really had oppositions who were prepared to articulate their reasons for their opposition on human rights grounds and not feel that they'll suffer at the polls as a result of doing that. But again, we've discovered, and we're discovering again in this next election happening in May this year, that governments are not particularly bold in relation to policies. The last time we brought out a Labor Party with a bold policy, they were destroyed by a very simple three-line government act. This is one big new tax, 4 words. And even though it wasn't one big new tax, that was enough to spook the population. Sorry. Question here. Hello, Jan.
I think it was your point number 4 about right to information.
Yeah.
Yes, right. One of the things that has always got me concerned, particularly once Scott Morrison became the Minister for trying to stop boats
Immigration or border security.
Immigration,
Yeah.
we didn't want.
Yeah.
Any time we wanted information or journalists asked for information about stopping the boats, there was this thing about you can't know. This is.
Yeah.
I could never understand why we couldn't know how many boats they were turning back, how far they came.
Yeah. There was legislation, not just a government fiat, but legislation that had passed through Parliament, with the government having the numbers, and through the Senate, with government having the numbers, that said that if you're a journalist, we can constrain what it is that you're saying. End of story. Now, the bottom line with that is that a civil libertarian would say that governments in those circumstances are in flagrant breach of the right of journalists to report things without fear or favour. And we did need to know how many boats there were. We did need to know whether our money was being appropriately spent on Manus Island. You know, the millions, if not billions of dollars that we've spent in the last 20 years in relation to those offshore detention centres, what that's costing us, who's getting those contracts, etc. But again, once governments, through the process, what's called the Principle of Legality, if the legislation has democratically gone through the Parliament, it has been very clear about what it's actually saying and not doing it by innuendo, then constitutionally that's upheld. And you might want to say it's in flagrant breach of our right to know. Of course, there are these bits of, the Data Availability and Transparency Bill, the Public Interest Disclosure Act, of course the Freedom of Information Acts. But all of those have riders on them that say that national security interests will have an overriding concern, and government would have said that level of scrutiny by opposition parliamentarians and journalists was beyond the pale.
I hear that we don't have a democracy.
Well, we do, insofar as if we don't like that, we vote that government out. And here's the importance again of an opposition parliament. In Parliament, the opposition should say, isn't this outrageous? And then, of course, the government comes back and says, they're soft on refugees, they're soft on boat people, they're soft on these illegals coming to our shores, and that spooks the population. In other words, I don't blame the parliamentarians, I blame the proletariat who are being sucked into that understanding that somehow or other it's in our best interests to have that level of obfuscation. Bruce.
Thanks, Rick, for your conversation tonight. I'm interested in whether the Civil Liberties Committee here in South Australia might be interested in pursuing the new Attorney General in one very, shameful area of Australian law, and that is its recognition of the prior ownership of this country by Aboriginal people. I know that the Marshall government tried to introduce the topic of a negotiated treaty within South Australia with 3 Aboriginal nations, but that failed only a year after it had started. And I wonder whether they might have good officers with the new Attorney General to pick that up and run with it.
Look, you're absolutely right. In fact, Kayamar is on record as saying that is actually going to be a priority. Now, not only does he have a portfolio of Attorney General, he has a portfolio of Indigenous or Aboriginal relations. He's in the upper house, yeah. He's the leader of the government in the upper house. And my view is that within the next 4 years, there will be some sort of statement from the heart which will apply to South Australia. I'm pretty sure there's already 1 or 2 in other jurisdictions at the moment around Australia. Don't quote me on that, but there have been precedents. The federal government is very nervous about that. I don't know whether the Albanese government would do anything differently, and he certainly wouldn't say that ahead of the election. That's the sad thing these days. If you say something ahead of the election, people start getting spooked, and that's the end of you. He's trying to do a ScoMo here, or just sort of sail under the horizon and just say, I just won't do anything to ruffle the feathers, and just kind of wait for them to fall over. It's not a particularly good way of having government come to be. In fact, you don't stand for anything. But that was successful back 3 years ago, and perhaps it's going to be successful in May. But I think you'll find that this government will do something symbolically if not tangibly, in relation to the way in which we will recognise the sovereignty of South Australian mobs, tribes, groups ahead of colonisation in 1836. And that would be a good thing, and civil libertarians would applaud that. I do want to take you back to 1992 with the recognition by the High Court of the Mabo land rights, which then gave rise to the Native Title Act. It's interesting, of course, because that was one of the very few cases where the courts were at the front of change and the Parliament fell in behind. They figured, well, the courts have already stated this, we now have to get this right in terms of what native title is going to look like. But in this instance, it's not coming from the courts in South Australia. It's going to have to come from the Parliament, and then the courts will fall in behind that. One might have thought it could be tied to a Human Rights Act, but I'm not holding my breath. Sorry, Fergus. I was going to say, again, this is all a question of balance. Do you think in your own minds, in terms of your own civil liberties, bearing in mind our privileged positions, we are not powerless, we're sort of the powerless end of this particular society, sorry, the powerful end of this particular society. Do you think we have the balance right? On all these issues, there's kind of a balance between what should happen and what shouldn't happen. And there's this wonderful quote that goes back to an American jurist that says that my freedom to swing my fist ends at the point your nose begins. And that's a very interesting way of talking about the balance that we love to have, this idea of freedom to associate, freedom to speak, freedom to criticise governments, freedom to promote human rights, freedom to have the privacy of our own homes and our own movements and our own banking and communications. But if those freedoms give rise to something which then becomes deleterious to the rest of society, then there has to be constraints on that. And that's where the legislation and the courts are constantly tussling with each other. Do you think we get that right? I'll put that question back to you. Bruce.
Can I say something else
Yeah.
there? In respect to that question...
Yeah. Margaret, can I have a bit of water, thanks?
In respect to that question, it seems to me that perhaps our quest for freedom seems to outweigh our quest for responsibilities. And if we have an act which specifies our freedoms, I think we should also have an act to specify our responsibilities.
Let me tell you that the Victorian legislation is called the Charter of Rights and Rights and Responsibilities. Responsibilities is absolutely part of that equation, Bruce. You're absolutely right that we can't just say, let it all hang out, let us all do what we like, without recognising that some of the decisions we make are going to have effects on others, and we have a responsibility. Thanks, Mark. So, in fact, for example, the whole discussion about religious freedom is premised on that. We have the right to have religious freedom, but if our religious freedom and making pronouncements about homosexuality or something are going to have the effect of distressing other people, then obviously we have a responsibility not to do that. So every decision we make concerning our freedoms has to be judged and balanced against how those freedoms will affect other people, how that fist of mine swings up to this particular nose is going to break that nose and cause someone some harm. I see Lily at the back.
One more question,
Yeah.
I reckon.
Thank you, Rick, for this very well-considered and very complex area. I'm just wondering if you want to comment on the facial recognition requirement that's now used by our government for people to obtain a visa to come to Australia. Even as tourists, they need to do this. What's it going to mean for us? How's it going to work for people? How's it not going to work for people?
Yeah. Thanks, Lily. It's the same Brave New World argument to say that I have no objection to that because it means I can go through the barriers in a nanosecond and I don't mind. We will take our photograph and we get out of customs very quickly and away we go. There are some people who make observations that it's actually racially discriminatory insofar as it actually doesn't work for certain people, therefore they're now going to be at the end of the line or it's just going to break down. It's one of those things that in some respects, I like the idea because it means that we are going to be far more secure in relation to people who may cause us harm. People who may have, terrorist ambitions or whatever are going to be less likely to come here if the effect of their having had their faces facially recognised will be caught up at a boundary or caught in a border somewhere. But a civil libertarian would simply say, let's make sure that the data are going to be used appropriately, that the data are not going to be used inappropriately, that their storage is going to be managed, that any private concerns that have facial recognition, like 7-Eleven stores, don't use it as a way of discriminating against certain people because they're Asian or Indian or other features. I don't have a difficulty with it in that regard, but we have to have some regulatory way of ensuring that whatever happens, the government legislation makes sure that it's not discriminatory, that it's not unfair, that it's transparent, that it's stored appropriately, etc., etc., etc. To that extent, you could say anything about whether it's, biotechnology, fingerprint technology. The fingerprint I have on my phone now just allows me to have a securer way of paying for bills rather than just waving a credit card that could be stolen by someone else. So, and I'm recognising too about CCTV. A lot of people are very worried about CCTV. I worry about the fact that if I'm walking down the street, CCTV is watching me at every step that I go. By the same token, if a young woman can then be protected from being hit over the head and dragged off somewhere by virtue of someone seeing the CCTV and recognising that they'll be seen and identified in that respect, then who am I to say that she shouldn't be protected? All I'm saying is a civil libertarian puts all those sorts of innovations, and those innovations keep coming, under a scrutiny to make sure that people are not discriminated against, that they're fair, they're transparent, they are not being used inappropriately, and the governments know what they're talking about. That's all I'm saying. Civil libertarians don't come out in a hard-nosed way and say this is wrong very often. They typically say when these innovations come up, let's put them through a series of pieces of scrutiny to make sure they're being fairly and non-discriminatory operations. Now so Margaret, do you want to say something? Over to you.
Yeah. I want to, Rick, don't go, because I want to thank Rick particularly tonight for coming, because this week has been a difficult time for he and his family, which some of you in the audience obviously know about. But there is in the book a wonderful story that I'd love you to read, and it's the retrieval of Lady Bernathan's ring, because it brings in his father and his grandfather.
Thank you, Margaret. I can find it here. That's easy. Yeah. And I should mention, yes, my father died on Monday night. He was 95. He was a remarkable man. Some of you may remember him as the storekeeper at Claude Sarre Jewellers for 49 and a half years. And he was a good man. And he was very pleased to depart this earth. And he loved telling the story. And I'll thank you, Margaret, for giving me an opportunity to read it to you, because we can say in some respect this is honouring him tonight, because this was his favourite story. He used to do the rounds of the various Rotary clubs and tell this story. It always got a good response. Here we go. Our father knew a fair bit about the retail industry, having worked in the family jewellery shop in Gawler Place, Adelaide, for almost 5 decades until the late 1990s. The business was started by my late grandfather Claude in the 1920s, and when Dad turned 22, as the oldest child, he was invited, shanghaied, into becoming his understudy. Now that Dad is well into his 90s, it's good that he can impart the key lesson that he learned in all of those years of retail trade. Keep customers happy and they'll come back again and again. Let them down and that'll be the end of them. And so it was that when one of Adelaide's most gracious and respected dowagers, Lady Bernathan, came through the door one day, Dad and his father wanted to be at their best. This was a customer who was well worth having as a regular. "Mr. Sarre," she said to Claude, "other jewellers in town have lost my valuable items from time to time. I need a jeweller that I can trust." She produced a diamond-encrusted ring. "I would like this one cleaned and sized, please." "Certainly," Claude replied. Dad took her details. They secured her ring in a beige-coloured envelope reserved for such work. Dad and Claude looked at each other in mutual appreciation. This was good business. In due course, the ring and the beige envelope came back from the workshop and was placed in the crowded returns box above the main counter, ready for Lady Bernathan's return. By telephone, she was advised accordingly. She replied that the following day she and her chauffeur would be calling in. Dad checked the box of envelopes. To his horror, Lady Bernathan's package was nowhere to be seen. He began to panic. He asked all the staff what may have happened. Conversations emerged about the box tipping over and all the envelopes being retrieved from the floor. It was not possible, was it, that Lady Bernathan's envelope had fallen to the ground below the shelf behind the counter where, as it happened, the waste paper basket was located. They decided that was the only credible explanation. The waste paper basket was regularly emptied into a large garbage skip that sat in the lane behind the shop. This bin took the refuse from all the surrounding shops, including a cafe. The rats loved it. It was now full of garbage, but there was no doubt the ring was somewhere in there. To his credit, my grandfather returned late that night and with his headlights on the skip and, ignoring the potential of being investigated by the local police or maligned by late-night revellers, he climbed into the bin and went through every last piece of detritus. At 3 a.m. he found the small beige envelope containing the ring. Lady Bernathan arrived on time next morning. Claude presented her with the ring. "Thank you, Mr. Sarre," she said. "I knew I could trust you."
It's a wonderful story, and it gives you a taste of what's to come if you get this book, Life Actually. And thank you very much for reading it, Rick, and thank you so much for coming tonight. And I have asked Jonathan if he'll officially thank you. Jonathan Barker has been on the Social Issues Committee of the Effective Living Centre for a long time. And Jonathan and Janine particularly are working with another committee, the Uluru Statement from the Heart Committee, where they're working to get people involved in that. And just like Rick talking tonight about the various things, the injustice of things, this is what the Uluru Statement Committee is doing too. And so I'm really pleased, Jonathan, that you can thank Rick for his night tonight.
Thank you, Margaret. Yes, I'm looking forward to reading your book, Rick, and those stories that are there. Your late father was a great raconteur, one of the funniest men I've actually ever met, I think. But I want to thank you for what you've done tonight. I'm not going to make a big speech here, just to say those liberties that you outlined for us tonight, it was just so good to hear the way you did them so succinctly and the way you illustrated each one of them. And I really want to applaud the Council of Civil Liberties for what you do, to know that there are people in our community who've got a list of things that will keep them awake at night if they're not seen to and someone doesn't do something about it or someone doesn't write letters and take action. And I just want to applaud you for that and all your other colleagues that do that. So it's been a great delight tonight to hear you speak again. We look forward to you joining us later on in the year when the Seminary of Third Age has got you up. And I can't even remember what the topic is, but at least there's a brochure out there, everybody. Please take one because that'll be another opportunity for you to hear Rick again.
I think it's on freedom of speech. I was talking about defamation law.
I think it might be. Yes, that's right. So, we want to thank you. Look, let's give Rick another round of applause. And on behalf of us all here at the Effective Living Centre, just a little token of our gratitude from tonight. Thank you.
Thank you, Jonathan. Appreciate it. Thank you.
I did bring two brochures. Jonathan has mentioned the one out there on the Seminary of the Third Age, or that's the one when Rick is speaking again this year. But if you don't know anything about the Effective Living Centre, pick this up and keep in touch with us. We have a website and you can find out on that what's available. I wanted to particularly pick up the next social issues, justice and equity night, and that is with Andrew Telfer. He has visited, he spent 3 months in Hebron in the West Bank of Palestine and Israel in the late 2019. He was an ecumenical accompanier to a particular group who went there. And he experienced all sorts of things, both on the Palestinian side and the Israeli side. And so he's speaking about injustice in the West Bank, a tale of two cities. So pick up one of these brochures, and if you can't come, you might like to pick it up and pass it on to someone else. So all it is for me to say, thank you all again for coming. Thank you once again for Rick being such a great supporter of the ELC, and please come and enjoy a cup of tea, a cup of coffee, biscuits or cheese, whatever you like.
And buy some books.
Of course, buy some books. Tanya is up there and she will sell them to you. Thank you.